languishing in custody. Even General Lekwot didn't know what was going on, to be honest with you. And I went to him, what happened, sir? He told me this story. And I related it to my comrades for Ghani. What is the general doing in the nation? Is he not supposed to be kept in a house arrest? Do you know any Nigerian general, serving or retired, who had never been brought to prison? He said no. The practice is to have you kept in a house. But please call the first in that respect. And we were there with him. Before we were told one day we were going to be released, we were going to Lagos, and General needed us to farewell. The vehicle maneuver, a few, about 35 minutes, and we landed in Gwagwalada Chief Magistrate Court, where we were charged with treasonable felony. We had no lawyer. We were even lucky you had a lawyer for some time. We had no lawyer. But two of us, three lawyers, Ghani and I, decided to defend ourselves and our colleagues. We addressed the court for 5 hours. We turned our trial to the trial of the regime and told the court, those who should be standing trial for treasonable felony were in the villa. Because they planned a coup. We never planned any coup. And so the judge said, please, I want to handle another case after this one. Of course, it went on. And from there, we were back to Brigade Prison. But when we were going out, we told General, we are going to take off your matter. None of the 5 of you will be executed in our country. And of course, we did. The book amounts to review. It's a riveting one on the macabre trial and death sentences illegally passed on Major General Zamani Lekwot and 5 other Zango-Kataf entities over the 1992 Zango-Kataf crisis and their ridiculous trial, which was marked with obvious judicial abuse by the tribunal. Chairman of the tribunal, Justice Benedict Okadipo, who a client of mine once referred to as injustice, Benedict Okadipo. And I'm talking of the late Fela Nicola. Incessantly delve into the arena during the trial, exhibiting patent and unbiased bias on a bastard part. The book encapsulates details of this judicial perfidy. It was like a scene from Stephen Tumin's epic book, Great Legal Disasters. In this 114-page book of 7 chapters, the author, Richard Akinola, deftly navigates the judicial intrigues and perfidy of the Civil Disturbances Judicial Tribunal, headed by Benedict Okadipo. In the foreword to the book, by Bishop Matthew Azan Kuka, the cleric said, and I quote him, sadly but truly, with military tribunals, judgments were often concluded before the tribunal itself was constituted. His job was often simply to present a semblance of process. Their duty was either to twist, turn, or manufacture evidence to achieve this end. These tribunals will go down as the greatest act of malfeasance against justice in our society. End of quote. The 7-chapter book started with an introduction to the crisis, particularly a letter dated February 3, 1940, written by the emir of Zazzau, Jafaru, to warn the Latu Muhammad, which to have set the stage of internecine ethnic conflict of attrition between the people referred to in the letters, unquote, infidels and the other settlers, effectively between the predominantly Christian Catholics, and the Muslims. The 1940 letter was introduced in the book. Chapter 1 of the book dealt with the initial charges against General Lekwot and 5 others, who were leaders in Zango Delta. The charges against them before the tribunal were that of unlawful assembly, only unlawful assembly. However, after the prosecution, witnesses had given evidence and defense had started giving their evidence, and the government realizing that the evidence of the defense could lead to their acquittal, the government dramatically filed a nolle prosequi, not willing to prosecute, discontinued the trial, and substituted it with a new charge of culpable homicide, punishable with death, and that was the beginning of the macabre drama. Unlawful assembly suddenly metamorphosed into homicide. The author came out with all the full text of the charges and the key rulings. Even when the defendants approached the Court of Appeal, in one of the rulings, the tribunal treated the appellate court with contempt and proceeded with the trial. From that stage, when the trial started, things took a dizzying dimension. As the tribunal chairman, Benedict Okadibo did not put anyone in doubt about his partiality, as he regularly had altercations with the defense team, ably led by the inimitable Chidioke Ajayi SN, a gentleman by excellence. He didn't belong to our own tradition. This is the gentleman who would talk quietly in court, but this judge had no patience for such a decent lawyer, because he had made up his mind and he was just in a hurry to hand down a death sentence. Now, there are several altercations which again confirm the bias of the judge. It reminds it reminds me of our own experience in Port Harcourt in the case of the Ogoni leaders, Kesarawa and others. Again, we're also compelled, just like Chidioke Ajayi, to withdraw our appearance. Because when you are talking law and the judge is not prepared to appreciate, your presence may be used to roll in and justify a terrible trial. And so we were compelled to withdraw, and that was what happened in the case of Zango Kata. This book details how the tribunal hurriedly adjourns after the withdrawal of the defense counsel for judgment, even when the prosecution had not concluded its own evidence. The judge forgot and just adjourned for judgment. It was therefore not a surprise that the tribunal condemned all the 6 defendants to death by hanging, and they were immediately moved to the condemned cell in the prison in Kaduna. The book details how the national and international human rights bodies rose to the occasion. Luckily, we kept together, and so we came out to let the world know the horrendous violation of the rights of General Lekwot and others. And of course, one of our group filed a petition before the African Commission on Human and People's Rights, and the commission issued a temporary injunction that thou shalt not execute them until the hearing of the substantive case. Of course, once we did that, we then approached a judge in Ikeja, Justice Onelaja, of blessed memory, who gave another stopping the planned execution. Since that petition was pending, thou shalt not execute. And Babangida wanted to pretend that it was civilized, so he had to comply with the judgment. He also ruled that by virtue of the African Charter on Human and People's Rights, he had the jurisdiction to adjudicate on the matter, contrary to the submission of the government council. And that stopped the Babangida junta from executing General Lekwot and the 5 others. By way of extrapolation, a similar move was also made by the same organization in the case of Kesarawa and others. But this time around, we're dealing with the more Tanzanist dictator, General Sani Abacha. As soon as that petition was filed, and the Commonwealth had just concluded its meeting in Australia and mandated the late Mandela to lead the delegation to Nigeria to appeal for clemency. Before they took off in Australia, Abacha ordered that Ken Sarawa and 8 other Ogoni leaders be executed. So General Lekwot is lucky to be in our midst today, and the other 5 The author also tweeted in chapter 6, series of newspaper editorial deprecating the macabre trial. While chapter 7, the last chapter, contained the decision of the African Commission on Human and People's Rights, nullifying the trial. This is a well-researched resource book that will enrich our discourse on judicial integrity and perfidy. It came at the right time, when there is ongoing public perception of our judges, our judge, being associated by political influences, a worrisome phenomenon that needs to be urgently addressed. I want to join Bishop Matthew Okuka again in congratulating the author for documenting this judicial perfidy for prosperity. As the bishop said, unquote, by laying bare the facts and letting them speak for themselves, Mr. Akinola has rendered a service to the people of Sango Kata. Not just to the people of Sango Kata, but to all those who are serious about the prospect of common citizens living together in peace and harmony with equal rights before the law in the same country. The struggle for justice is often a lonely one, but Richard has done great service by laying bare the facts of the saga. This book is a blueprint of love, a valuable beacon for all those who struggle for justice and peace. End of quote. Let me come by reminding all of us, the struggle for justice in our country is a Herculean task. Just this morning before this program commenced, I was in the court in Abuja here, where 119 Nigerians, including 29 minors, were brought to court. But the government was so ashamed that they couldn't take them to the courtroom unlike last week. And of course, I will be defeated by the public. The government came to the court this morning to withdraw the frivolous charges. And so, the young people have been freed. But as I did say to the court, it's not enough to terminate this trial. These young people, who ordinarily should have been in school during the protest, must be rehabilitated by the government, and we are going to ensure that they are rehabilitated. If the government fails, we are going to court to sue the government because it is the responsibility of the government, by virtue of the Child Rights Law, which has been adopted and enacted into law by all the states of the Federation. Madam Deputy Governor, Section 15 of that law provides that every child in Nigeria shall be given free and compulsory education from primary to junior secondary school. This time around, we are going to ensure that these children are given education free up to senior secondary school. Thank you very much.